Good afternoon. We will study Chapter 7, Part 2, Application of Logic. In this part, we will study the application of logic in law. We already know that logic is the process of proper inference. It is a system of proper thinking, means the thinking in right direction to arrive at the correct conclusion. Proper thinking is based on the principles which govern the validity of arguments, and logic provides appropriate standards to determine if our beliefs are consistent with each other and confirms it by evidence. Logic is the ethics of thought and belief, as it separates the right thinking from wrong thinking. It discovers the truth about truth. That is, it represents reality. Now, what is law? Law is nothing but a statement of general truth. That is, the truth which holds universally. And what will be the aim of main purpose of a lawyer? The main purpose of a lawyer is to present his own position convincingly and demolish the opponent's argument effectively. For both the cases, knowledge of logic is helpful. Knowledge of the principles of logic empowers us to reason correctly by training us to differentiate between good and bad reasoning. And therefore, logic is very important in legal trials than any other field. Every legal analysis should begin at the point of reason, continue along a path of logic, and arrive at a fundamentally fair result. What do you understand by this? It means that when there is a dispute between the two parties and they approach the court, then the lawyers have to analyze the matter by, by giving reasons. And this they can do by continuously following the path of logic, and they can arrive at fair judgment which can be accepted by both the parties. It is important for practitioners as well as students of law to understand the basic principles of logic that are used in legal reasoning and judicial decision making. So, the practitioners and the students of law, they must understand the basic principles of logic. Why? Because they have to use them in legal reasoning and judicial decision making. Then let us see how logic is used in law. First is evaluating, creating and presenting arguments. Evaluating and creating arguments is essential for a lawyer and a judge. Arguments are of two types. First is the inductive argument. We know that an inductive argument is that argument in which the premises do not provide sufficient evidence for the conclusion, whereas deductive argument is that argument in which the premises provide sufficient evidence for the conclusion. How are these two arguments or methods used in law? First is for theoretical purpose. The lawyer becomes aware of the types of arguments and learns how to reason and present them. Secondly, practical use. Practically, the lawyer uses these two different methods in two different courts and tries to solve the disputes between the two parties. There are two types of courts. First is the trial court, where inductive reasoning is used. The trial is a structured process where the facts of a case are presented to a jury and the lawyers decide if the defendant is guilty or not of the charges offered. During trial, the prosecutors uses witnesses and evidence to prove to the jury that the defendant committed the crime. But the disputes rarely are solved in this court. So the losing party appeals to the appellate court where deductive reasoning is used. Appellate courts do not retry cases or hear new evidences. They also do not hear witness testify. There is no jury. The appellate court reviews the procedures and the decisions in the trial court to make sure that the proceedings were fair and proper laws were correctly applied. So, the lawyer's understanding should improve. This includes expertise in using inductive reasoning. We know that inductive reasoning are of four types. The first is simple enumeration, the method of simple enumeration, in which the inference is drawn on the basis of the past experiences and empirical observation. And in our observation, we do not find any contradiction or contradictory instance. So what is true of the few instances is said to be true of all the instances of that kind. Then the second is the method of analogy, where the inference is drawn on the basis of resemblances between two things. They resemble in certain quality, one has an additional quality, therefore we conclude that the other also has. So the rule of law that like cases be decided alike is seen logically in inductive reasoning. Second, elementary understanding of deductive logic, especially of argument forms called syllogism, gives lawyers, judges, and students of law a valuable tool for deciding whether an argument in a legal opinion is valid or fallacious. That is, the lawyers come to know whether the argument is legally valid or invalid by using syllogism or having the knowledge of logic, especially that of syllogism. Second is precision in use of language. That means the language which is used in law should be very precise, to the point and clear, for which knowledge of logic is necessary. The role of logic is significant in three important aspects of legal system. First is making the law, second is executing the law, and third is interpreting the law. Now, in making the law, the lawyers have to be very careful regarding, first, the laws should not be vague and ambiguous. Vague means what it applies should be clear. Means whether it applies to this or not, that should be clear. And ambiguous means the law should not have double meaning, means its meaning should be clear from the context in which it is applied. Then secondly, the law ought to be very clear and precise. Clear means whatever the language which is used in to explain that law should be clear so that when read is understood by the person, and should be precise to the point. Then the details are also necessary in drafting the contracts, wills, trust, and other legal documents. Now you know that contracts are made, wills are made. Wills means a document which indicates that after the person dies, to whom the property is inherited. That is given in the will, where the language should be very clear and precise, so that there will not be any disputes. And then the even the trust, the property is sometimes given to a trust to take care after the death of the person. So all the documentation done should be very clear, precise, free from vagueness and ambiguity. This is possible when the words used in laws are properly defined. So definition, the knowledge of definition in logic is very, very important in this matters. The knowledge of the principles of logic is important and necessary for making laws and legal documents. Now we come to executing of laws. While enforcing these laws on others, what care the lawyer has to take. Execution of laws is essential aspect of legal system, and the main function of judicial system is to resolve the disputes. That we already know, that we want to resolve the disputes, and so that parties come approach the lawyers, and it is necessary that the lawyers give them a judgment which is definite and very fair to both the parties, can be accepted by both the parties. The entire process of legal trial is based on the application of the principle of logic, and knowledge of different types of fallacies is very, very useful in legal trials. What is fallacies? Fallacies are errors in the argument. So if you have the knowledge of different types of errors committed in an argument, then it will help the lawyer, enable him to detect the errors in the opponent's argument as well as to argue correctly, justify one's own stand. We already know that the main purpose of a lawyer is to maintain his position by demolishing the opponent argument, right? So he can do this only if he has the knowledge of fallacies. Interpretation of laws, which means explanation of laws. Finally, by applying the principles of logic, argumentation of lawyers is evaluated, means tested, whether it is valid or invalid by giving evidences before the court, and those evidences are weighed. How much weightage does they have, whether they are genuine or not, and then the fair judgment is arrived or made. For resolving disputes, sometimes what happens, the legal system has to apply some laws or rules or principles to a set of facts so that the judgment is possible. Sometimes the dispute does not resolve, and so there is a need to apply some law or rule so that they can get some solution to the problem. For example, one lawyer may argue to defend his client that a specific rule applies to the fact, while his opponent may say that no, it does not apply. In such cases, the knowledge of logic is useful in correct interpretation of the law or rule. Here, the knowledge of definition is very, very important. Let us take another example where there was a dispute between the government and the cashew nut dealer. The government had levied taxes on vegetable products, and the cashew nut dealer said that cashew nut is a fruit, so that he has not to pay the taxes on the product, whereas the government said that it is a vegetable, and so there was a dispute between the two parties, and they approached the court, where the matter was solved by defining the word vegetable, and it was considered that cashew nut is a fruit and not a vegetable. So we have learned how logic is used in law. I hope the law students also use logic in their judgments. Thank you.